Boker Tov. Good morning. I'm Dore Gold. I'm the president of the Jerusalem Center for Public Affairs. I'll be making a few remarks in English, probably because there's some legal terminology that I want to use, and I will inaccurately translate it into Hebrew. But also we have a foreign audience here as well as an Israeli audience. I think it's useful before we get started, and I'm just making some introductory remarks, to tell you a little bit about how an idea is generated. The idea for this conference, the idea of the legal project that we have at the Jerusalem Center for Public Affairs, and our cooperative relationship with the Konrad Adenauer Foundation and with Lars Hansel, who will be shortly addressing you. In any event, many of you might remember that on July 9th, 2004, the International Court of Justice in The Hague issued what was called an advisory opinion as a result, as a consequence of a report by the UN General Assembly. And the legal opinion was on what they called the legal consequences of what we know as Israel's security fence. In the actual UN language they used, of course, they describe it as a wall, and they describe it as a wall on Palestinian territory. To bring you back to 2004, the ICJ, the International Court of Justice, held, among other things, in paragraph 139 of its advisory opinion, that the right of self-defense, the famous Article 51 of the United Nations Charter, only applies in the case of an armed attack by one state against another state. The entire advisory opinion was, at the time, somewhat of a, I would say, just a distortion of the entire UN system. The whole question of contentious issues between parties normally have to be agreed upon by both parties in order to go to the International Court of Justice of The Hague and give them jurisdiction. The Palestinian, the PLO at the time at the UN, basically did an end run around the legal system of the United Nations and had the General Assembly ask for an opinion of the International Court of Justice instead of having the parties themselves request the opinion. Therefore, it was an advisory opinion. It was still issued, but it was non-binding. Now, that particular sentence in the advisory opinion, saying that if Israel argued the case that it was exercising its right of self-defense by building the security fence, by them saying that, well, sorry, the right of self-defense state actor, that opened up a huge debate about whether international law could be used in the kinds of conflicts we're facing in the present and in the future, in which non-state actors, from Hamas to Hezbollah to Al-Qaeda, whether those non-state actors could be governed in any way by international law. Now, at the time, the U.S. ambassador to the United Nations was John Danforth. And he clarified in the General Assembly of the United Nations on July 16th, 2004, that the United States opposed the advisory opinion. And he said that the court opinion seems to say that the right of self-defense does not exist against non-state actors. It does not exist when terrorists hijack planes and fly them into buildings, or bomb train stations, or bomb bus stops, or put poison gas into subways. So what basically this statement of the U.S. ambassador and the advisory opinion itself and the debate that ensued over this advisory opinion did is it really revealed the gross asymmetry that was evolving in international law in cases where states wish to defend themselves against suicide bombing attacks, against attacks of any sort against their civilians. It seemed that states have defined responsibilities because they're signatories to all kinds of international conventions, but non-state actors are completely free. Now, this fundamental problem that we discovered in 2004 completely was unveiled in Operation Cast Lead in the Gaza War, where Hamas was attacking Israeli civilians repeatedly for 8 years. And yet when Israel exercised its right of self-defense against Hamas, it suddenly came under a shower of international criticism, much of it disguised in the language of international law. And this leaves us with a fundamental choice of what to do in the future. Should we resent this and therefore ignore the norms of international law? Many might be tempted to do that. Or should we call for a change and an evolution of international law so that international law is basically used to defend Israel's interests and not just the interests of our adversaries? And I think that's at the heart of our conference today. And I'm sure speakers will address this issue from different angles. So it obviously is important that international law not just address what states do, but what these non-state actors do. And hopefully we will begin to get a full reading and a full understanding of how we can affect the growth of international law so that it begins to respond to the real security environment that we face. So I will now turn over the floor to Lars Hansel, who has been our partner so many times at critical events that have helped edify the public in Israel and have helped stimulate positive debate on some of the most critical issues of our time. And I thank the Konrad Adenauer Stiftung for helping us in this in the past and for being a full partner in crafting these conferences, and again, this conference as well. Lars?